Hello, everyone. So we got started a little early today. I scheduled the live to start at 2 p.m. We are a couple minutes early. I do hope that's not a problem for anyone. It looks like the court had some motion practice that it was going to engage in before we got started with the actual trial today. And they're actually broadcasting that motion practice. So I did jump on here a little early so that we could try to catch that motion practice and see what the court's talking about, see how they deal with whatever motions are being raised by either the prosecution or the defense. So it's good to see that, at least a few people are here. Good to see you, Jeff. I'm sure a couple people are going to join us. So we're going to begin apparently with some motion practice, like I said, and then the trial is going to likely pick up after that. So let's see where this motion practice goes. If you're not there for the motion practice, you really won't miss anything. I'll probably recap whatever happened during the motion practice later on during the live. At some point, probably during a break, I'll let everybody know what happened during this particular motion practice piece. So if you all want to grab a snack or something and don't really care about the motion practice, go grab a snack. But we're going to get started.
In establishing her probable cause, and we would anticipate the 3 vehicles.
All right, so it sounds like the audio is going to start before we get the actual video. So I did have to rewind.
3 vehicles being washed. It was just to focus on the one which I know we addressed yesterday in Detective Gaddis's testimony. He was concerned about the anonymous tips, the number of people in reference to the anonymous tips, certain conclusions that Detective Gaddis arrived in establishing her probable cause, and we would anticipate in basically roughly him testifying to the same thing as had been previously addressed before the court in our motion, in our renewed motion, since my being retained concerning the Franks v. Delaware motion.
Okay, and I do recall reading that report. You're not going to call him first, right?
No.
I mean, so at lunch I can review his report again?
Thank you, yes.
And then make a determination, so I'm assuming the state's making a motion to not allow?
Yeah.
Okay, I just want to be able to review that report again.
Understood, and we have noticed him up as an expert witness. We have him available, and obviously we do this prior to the trial starting to see where the evidence is, the state of the evidence that's been presented by the state. He is available to testify. I've explained the concerns that the state has, and perhaps Your Honor would have with his proposed testimony, and we anticipate Your Honor wanting a proffer, but I've provided ahead of time his opinion by way of proffer so the court knows the sum and substance of his testimony.
Okay, and so you won't call him before the lunch hour then?
We will not.
Okay, I mean,
Sure. Okay. Your Honor, so we were, yesterday, after court, we were provided with a series of proposed exhibits. I think the state has some concerns as to the admissibility as to a number of them. So our thought was maybe if we could address maybe some of the issues regarding admissibility now. What I didn't want to do is perpetually interrupt witnesses with objections on this. And certainly if we had had these a little earlier, we could have at least maybe brought these concerns up.
who's your first witness?
It would be Dr. Mark Chambers, and what we would propose to the court, because this case has been moving forward so efficiently, a number of people are going to be available at the end of the week. We've been reaching out, trying to get people to move their schedules to be available today. There's been some difficulties in reference to that. What we anticipate doing is calling Dr. Mark Chambers this morning and then having a break so we could address these issues that should be addressed out of the presence of the jury to avoid an interrupted presentation of the defense's case.
Okay, so you're only going to have one witness today?
Correct. As of right now, we're waiting for another witness. She had called Crime Stoppers. She was available tomorrow. We're trying to move her up till this morning. We called the hallway. She is not present yet. Again, everybody was subpoenaed to testify towards the end of the week. So we're trying to accommodate the real-time schedule of this trial.
Okay, so we could let the jury go, but we could deal with some of these exhibits?
Correct.
Certainly.
All right, but we don't have to do it before Dr. Chambers
No,
comes
we can
in.
put Dr. Chambers on.
Okay,
Judge, can I have the evidence proposed so I can make a record of what was being objected to?
right, before, I mean, we could probably do that at the
Yeah,
break.
the other thing is, I believe the defense will stipulate to, the admission of 312 and then 316 to 336.
That is correct, and obviously the purpose of stipulations is to make the trial process smoother and better presentation of evidence to the jury, and obviously we anticipate participation in the same way from the state concerning our exhibits. But yes, we stipulate the admission of those exhibits. I'm going to approach your clerk with our defense exhibits,
Okay,
additional defense exhibits. I believe we're up to X.
so these are the ones the clerk's gonna mark.
Correct.
Okay,
Okay,
perfect.
so we can make a record. We are, yes, we're on X right now.
And the only other thing, Your Honor, is remember how I talked about having a flash drive of the long form of all the video?
Right.
The defense raised a couple concerns. I'm just deleting the images they don't want on there to go back to the jury. I want them to check my work to make sure I remove what they wanted, and then we'll be offering that.
Okay. All right, can we bring the panel in?
As far as the state's concerned, yes.
All right, we can bring the panel in.
Thank you, everyone, please be seated.
Does the state stipulate to the presence of the panel?
Yes, Your Honor.
Any defense?
Yes, Your Honor.
Okay, Mr. Jaskowitz, you may call your first
Yes,
witness.
the defense calls Dr. Mark Chambers.
Please remain standing, doctor, and raise your right hand, face the clerk.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Thank you.
Please state and spell your first and last name for the record.
Mark Chambers, MARKCHAMBERS.
Thank you. Dr. Chambers, if you could begin by telling us a little bit about yourself, beginning with your education.
All right. I attended undergraduate studies at Stanford University, where I graduated with a major in psychology and a minor in biology. I graduated with distinction, which meant that I was in the top 10% of my class. I also was admitted to Phi Beta Kappa during that time. I also earned a master's degree at Stanford in education, My doctoral studies were conducted at Northwestern University, where I earned a degree in clinical psychology.
How are you currently employed?
I am self-employed with a practice in clinical and forensic psychology.
If you could please explain to us the difference between clinical psychology versus forensic psychology.
Clinical psychology is probably what most people think about when they think about psychology or psychologists. A clinical psychologist deals with problems in the human condition, mental disorders, or other kinds of personal problems people may have in their lives, like depression or anxiety. They do psychological testing to help better understand a person's issues or problems or situation, and then they provide treatment services, which we usually refer to as psychotherapy or counseling.
If you could explain to us too a little more in detail what is psychology. I think we all have a pretty general idea, but if we could just address that this morning.
Psychology is the science of behavior, and although most people might think of it as relating to thought processes or something that goes on inside the brain, that's not something that we can access directly with any kind of psychological or scientific methods. So we have to look at people's behavior, and then from that we sometimes infer things about the way that the human brain works or why people behave the way they do, but ultimately we are looking at behavior and then drawing conclusions from that.
In reference to forensic psychology, which you have been qualified in previous hearings to give expert testimony concerning, is it fair to say that psychology is basically taking well-accepted principles, scientific principles concerning human behavior and applying it to specific circumstances?
Yes, and those specific circumstances are related to some sort of court issue. So a forensic psychologist may do work in family court, conducting evaluations or child custody assessments. They may work in criminal courts like this one here to provide expert testimony that might help the trier of fact, either the judge or the jury, to understand a particular issue that's germane to the case. Sometimes we also work in lawsuits and provide testimony about maybe in a car accident what kind of psychological trauma an individual has sustained. But ultimately, as you said, forensic psychology is the application of basic psychological principles and research to the issue at hand in the court-related proceeding. And as a result of that, a forensic psychologist sometimes has to be a little bit of a jack of all trades, because there are a lot of different areas of psychology that can apply to a court-related setting, and so we have to know a little bit about a lot of different things.
Okay, would you kind of, I guess, analogize that to that of a coroner? I mean, a coroner is called upon to give an opinion concerning manner of death.
Certainly, yes. A coroner has to know about head injuries and gunshot wounds and blunt force trauma and poisoning and all different ways of death that somebody might experience. So they can't be an expert in any one of those areas. They kind of have to know all of those things so that when they perform an autopsy, they can bring that knowledge to bear to determine the cause of death.
So we have scientific principles applied to specific fact scenarios that help judges, juries make certain determinations concerning issues of fact. Fair to say?
That's fair to say, yes.
You've given and been qualified to give testimony concerning eyewitness identification. If you could, and other matters, if you could please explain to us other areas in which you have been qualified and given expert testimony concerning.
Sure. One of the big things that I often testify about has to do with the reliability of memory, because a lot of court proceedings rely on the testimony of witnesses, and by virtue of that, the reliability of their memory as to what they observed or experienced or what kind of testimony they're bringing to the court. So there's a lot of research on how memory works, the way in which it can be defective, and that can be helpful to the trier of fact to judge the credibility or reliability of a particular witness's testimony rather than just assuming that whatever they say is automatically true. I've also testified about the effects of various medications or substances on behavior, including drugs and alcohol, because those things can distort the way people behave, the way that they think, the way that they react to certain situations, and so that can be helpful to know. Stressful situations, trauma can also affect a person's behavior and reactions to certain situations, and so it can be helpful for a trier of fact to know more about that before making a judgment about the case in front of them.
And just so I'm clear then, you've been qualified to give testimony as a forensic psychologist, and as a forensic psychologist, your testimony could address a whole myriad of situations that affect people's behavior and why they do things.
That is correct, yes.
You have been called on in prior cases by defense counsel,
Yes.
myself included.
Correct.
Have you been called upon to give testimony as a forensic psychologist in prosecutions?
I certainly have, yes.
Federal cases, state cases, if you could please explain to us just briefly your involvement in prosecutions.
I've testified and consulted all over the world, and I think if I had to add them up, the number of prosecution versus defense cases is pretty evenly matched. But I've testified in family court, I've testified in civil court, I've testified in military and federal courts, as I said, in many, many jurisdictions.
And when you're called upon, let's say by a defense team or a defense attorney, you are not retained to give a specific opinion, fair to say?
No, I'm here
Being defense-oriented or prosecution-oriented, something along those
Correct.
lines.
I'm here to elucidate the relevant psychological principles and research and knowledge that will help the trier of fact better understand a case. In some cases, it's not favorable to the party that is consulting me, and I have to tell them, I'm sorry, I can't help you because the research says this, and that's probably bad for your case. And that's okay. I mean, sometimes that means a little loss of work, but I've got plenty of work, so that's not really a concern for me.
In reference to these scientific principles upon which you draw opinions or conclusions, you're not a research psychologist.
I am not. I mean, I was trained in research. I have done research, but in my role as a forensic psychologist, my primary skill is understanding research, being able to read research studies that have been published by other researchers, and then gleaning from that the appropriate principles and understanding about human behavior that's relevant to the case.
And these research studies, again, fair to say, cover a wide array of circumstances.
Correct.
Your job is to review the research. And let me ask you this, the research, whether it be concerning false confessions, whether it be concerning memory, it's open to peer review. And if you could explain that to us.
Sure. So the peer review process is a safeguard to make sure that research that is published has done the things that it needs to do to be reliable. So if a research team conducts a study and then they coalesce their findings and then they put together a paper or an article that they'd like to publish, they then submit it to the journal that they would like to publish it, and then that journal sends the draft of the study to a couple of other experts in the field who then look it over, they critique it, they make suggestions of what things could be done better or questions that they feel like they have that the study doesn't answer that need to be answered in the study. And in most cases then, the study, if the editor of the journal feels like it still has merit despite the criticisms, it will send it back to the researchers with the suggestions and say, hey, can you make these changes and we'll take another look at it. Sometimes they'll accept it or reject it immediately, but most of the time it's that middle ground where they try to give some guidance to the researchers on how the paper can be better and more suitable for publication. So by the time a study gets published in a scientific journal, in a peer-reviewed scientific journal, it has been looked over by several sets of eyes, not just the researchers who are submitting the paper.
When you're called upon to give expert testimony concerning issues in the case, sometimes you're called upon to give a wide variety of opinions, and sometimes you're called upon to give a very narrowly tailored opinion as to perhaps a single topic or
Yes,
subject.
I think that's fair to say.
And in this case, you were retained to give testimony in the state of Nevada versus Robert Tellis.
Correct.
Did I reach out to you in reference to this case?
No, I believe that I was originally retained on this case by the defense investigator.
Okay, and that
You
was
reached
prior
out
to
to
my
me.
involvement, to your knowledge, in this matter.
That's my understanding, yes.
You were called upon to review certain evidence in this case, to give testimony concerning suicide attempts for those that are involving charges or
Yes.
facing charges.
That's correct.
Let's talk about this. You know, individuals who may be charged with a crime attempting to commit suicide. How common is it?
Well, first of all, it's hard to say because there's a lot of people that go into custody, but it's not very common. I think it's fair to say that it's probably less than 1 in 1,000 suspects or defendants who are involved in the criminal justice system. So it's not particularly common, but it is more common than it is in the general public. So people who are involved in the criminal justice system do commit suicide or attempt suicide at a higher rate than the general public.
Are there risk factors that have been identified by peer-reviewed scientific research on this issue?
Well, yes. One of the risk factors that has been identified is the severity of the crime, the severity of the charge. So if somebody is accused of a particularly severe charge, then the risk for suicide or an attempted suicide is higher.
Fair to say that the severity of a murder charge is about as serious as it can get.
I would think so.
Is an attempted suicide a reliable indicator of a guilty conscience?
Not necessarily, no.
And is that based upon research?
Yes.
And if you could explain this issue.
So there, in 2011, there was a study published of a very comprehensive research project where they looked at over 27,000 suicides that were committed by individuals who were involved in the criminal justice system. And then they compared those individuals to over 500,000 individuals who were also involved in the criminal justice system but did not commit suicide. So that they could identify, well, what makes these people a little bit different than the people who didn't commit suicide? First of all, I think it probably is obvious that individuals who came in with a mental health problem were already at higher risk because those are the people that typically commit suicide. So it wouldn't necessarily have anything to do with whether they're being charged or not, but it's clear from the research that the stress of being accused of a crime, particularly a severe crime, as I said, can cause people to commit or attempt suicide, whether they're guilty or not. And for the study that I reference, for instance, found that there were people who had gone through the system, were adjudicated not guilty, and after their case was done, they were still at a higher risk for suicide. Other people who had their cases dropped, but had still been accused of this crime, were at a higher risk for suicide. So it was clear from the study that it's more the process of being involved in the criminal justice system, being accused of a crime, that produces the stress that can result in suicide than guilty conscience itself. And I should add, part of the problem that even addressing that question of guilty conscience is that, remember I said earlier about what psychology is and it isn't. It's about behavior, it's not about mental processes. So to accurately answer that question, we would have to know what's in the brain of the individual. Guilty conscience, by definition, regards what's going on inside, not what the person is doing. And so we can't, there are going to be many, many cases where we don't know if the person is guilty or not. So it becomes difficult to answer that question. But we do know that some people, even after they have been found not guilty by the system, just being involved in the system is a suicide risk.
And just so we're clear, you're not called upon to give testimony concerning the guilt or innocence of Mr. Tellis.
No, of course not.
That's obviously within the purview of this jury and not yours.
Absolutely.
So just so I'm clear on your testimony, if a person attempts to commit suicide after being accused of the crime, that doesn't mean that they probably did.
It's not a reliable indicator, no.
Innocent people or people that have been exonerated of a very serious crime have attempted suicide.
Yes,
You are aware that Mr. Tellis cut his arms pretty severely in this case.
I am.
So I want to point out something that he's not saying. So those individuals who are found not guilty of a crime for which they have been charged are, according to this study that he is referring to, still attempting suicides. To some portion of them, some percentage of them are still attempting suicides after they've been exonerated. But our criminal justice system is necessarily makes it difficult to obtain a verdict of guilt. Our justice system is designed to ensure that only the guilty are incarcerated. So we knowingly allow people who are guilty to go free to help ensure that we don't incarcerate people who are not guilty. I say that to say this. Just because someone is found not guilty by a jury of their peers doesn't mean they're not guilty, which means that it could still be that their guilty conscience is what is triggering the suicide attempt after they've been exonerated by a jury of their peers. So I just want to point that out. Perhaps the prosecution will get into that. We'll see.
Did you have an opportunity to discuss this issue with Mr. Tellis?
I did.
Did he express to you concerns that he had at the time that he did this?
Objection, hearsay.
Was his explanation to you consistent with the studies that you have just referred to?
Objection, hearsay.
Again, you have given testimony concerning these studies where a person gets accused, and as a result of the accusation and the process, not necessarily guilt, but the accusation and the process, that person attempted suicide.
Yes.
And that attempted suicide does not necessarily mean a guilty conscience.
Correct.
Thank you. I have no further questions.
Thank you. Good morning, sir.
Good morning.
Can I have some sort of overview of what you reviewed in preparation for your testimony this morning?
Certainly. I was sent the discovery from the case, which I believe included.
So before she gets too far into this, you never want, as an attorney, you don't want to get into the science with the expert witness because they know more than you. So hopefully she doesn't start going all deep into the science of this thing. She needs to have picked a topic already to cast doubt in the juror's mind as to whatever it is he's opining to. Stick to that topic and not get too deep into the science, because if she gets deep into the science, he's going to make her look like a fool.
Did the police report, which essentially documents the investigative process that the police went through when they were assigned to this case. I think that also included some hospital records for the defendant when he was hospitalized immediately after his arrest because of the injuries to his arms. I think I saw some photos that were related to the case, and I was also provided with medical records for the defendant during his time in custody at Clark County Detention Center.
Okay, and in terms of the police reports, you mentioned that you had we call it the OR, the officer's report. Is that what you're referring to?
I believe so, yes.
Okay. How about any witness statements? Have you reviewed any of those?
I believe there were witness statements in there as well, yes.
Okay, and then did you review photographs associated with the case?
As I mentioned earlier, yes.
Video,
Don't recall seeing any video.
DNA reports?
I think I saw some DNA reports, yes.
Reports from like phone extractions, anything like that?
I think I saw a log of some phone records, so I'm not sure if that's what you're referring to.
I'm talking more like the contents of a phone?
I don't recall seeing that, but that doesn't mean I didn't.
Okay. And when was it that you were provided these materials?
It was some time ago. I was retained on this case, I believe, late last year, but I couldn't tell you the exact date.
Okay. And it sounds like you interviewed Mr. Tellis at some point?
I did.
When was that?
I actually interviewed him twice. I interviewed him earlier this year, I believe, and then I also interviewed him last Saturday.
Okay. And in either interview, did you record your conversation with him?
I did not.
Did you take notes?
I did.
Are your notes available?
I'm not sure what you mean by that.
Well, do you still have your notes?
Yes,
Okay, so if the court ordered you to provide them, you could do that?
I could, yes.
Okay. And you understand, of course, we don't have them yet.
I haven't been asked for them, no.
Okay. And so if we made that request and the court agrees with us, you'd be able to provide it?
Certainly.
Okay. Besides Mr. Tellis, did you interview anyone else?
I did not.
How long were the interviews that you conducted with him?
The first interview was about 3 hours, I believe, and then the more recent one was maybe an hour and a half.
Okay. Did you ever administer any tests to him?
I did not.
So it was just interviews, and so you're sort of relying on his description of events?
Well, I mean, I captured his description of events.
Okay. But what he's telling you is his factual version, right?
I would assume so.
Okay. I mean, you don't ever verify that with anybody else, is that fair?
I have not.
Okay. And so you're kind of getting information from a single source?
Well, I'm getting information from him for the information that he has available to him.
Okay, and like you could apply, I mean, sometimes are tests administered in order to do psychological assessments of people?
Correct.
And none of those were done
No,
on either occasion?
no.
Okay. And you're not here to tell us anything about events that occurred on December the 2nd of 2022, correct?
Well, no.
No. I mean,
Not-
you
not
haven't.
on that date, no.
You haven't been to Bronze Circle?
Counsel, I believe it's September 2nd. There was a question. December 2nd, I think.
Oh, I thought I said
Just a
September.
mistake,
I
no
apologize.
worries.
I mean September, if I misspoke.
Yes, no,
I mean, you haven't been to Bronze Circle.
no.
You're not familiar with any of the evidence other than what you read in the officer's report?
Whatever I read in the police report, yes.
Okay. Now, you mentioned that, you sometimes testify like about the reliability of memory and that sort of thing, and that is sometimes used in cases where there is eyewitness testimony to be relied upon.
Yes,
And then sometimes I would assume it's to talk about like children who recall instances of sexual abuse that occurred in the past. They're challenging their memories of that.
that's right.
And so you kind of provide, I guess, context to how they might misremember things.
In some cases, yes.
Okay. And I think you said on direct examination that, that going through the criminal justice system just in itself is a stressful event,
Yes, certainly.
and that correlates with the severity of the charge.
The risk of suicide correlates with the severity of the charge, yes.
Okay. And what we're saying is, I think you said it doesn't, I think your words were not necessarily when asked if it was, like the suicidality was indicative of a guilty conscience, correct?
Yes,
And so not necessarily to me means sometimes it could be?
sure, of
Okay.
course.
So there are sometimes people are suicidal because of feeling guilty about the crime they've committed?
I think that's almost certainly true.
Okay. Do you have any kind of information? I don't know if there are studies on that.
So I specifically wrote down that his response to that question was not necessarily, just to see if the prosecution was going to come back to it. Anytime an expert witness says not necessarily or something that leaves any wiggle room, you definitely, if you're on the other side, want to go back, hit that question, remind the jury that expert left some room open for the alternate answer to be the case. In this case, he's left room for a guilty conscience to cause people to attempt suicide.
About how often that might be the case.
Well, because, as I said earlier, we don't know what's going through a person's mind in most cases unless they tell us.
Right.
People that commit suicide don't usually have much to say.
Right, but if
And
you
so-
attempted it, you
Right,
would.
and even when they tell us, we can't always rely on that as being accurate. So it's a very difficult question to address directly through scientific study.
Because people who have attempted suicide may be unreliable narrators about why they did things, right?
Absolutely,
And they may be self-interested when they're relaying events to you.
for sure.
And they may be motivated by sort of wanting to avoid criminal responsibility when they're talking to you.
Yes, definitely.
So here's what she's getting at. If you have committed a crime and the psychologist is asking you, did you commit suicide because you committed that crime? Of course you're going to say no. Of course you're not going to directly link it to your guilty conscience, because then you're telling the world, I just killed a guy. So as she's pointing out, this field of science is necessarily flawed because they can't get to accurate information because everybody's going to lie to them. Well, anybody who would answer in the affirmative as to whether or not they killed a guy and that's the reason that they're attempting suicide is either already behind bars or the attempted suicide was successful. No one else is really going to answer in the affirmative.
All those factors are always at play when you have someone charged with a crime. Would that be fair?
They can be.
Okay. And do you think there's a correlation of suicidality when people, like in high positions in society, have what's called like a fall from grace? Do you know what I mean? Being publicly embarrassed?
Yes, I think that that's probably a factor, because when I talk about the stress of being accused of a crime, whether or not you did it, there are a lot of factors that play into that. There's family, there's friends, there's finances, there's your employment, but also, as you said, if it's somebody who has a prominent position in society, just the public scrutiny of being accused, whether you're guilty or not, is sometimes inescapable. And we see cases of that all the time where people are accused of a crime, they're tried, they're found not guilty, but that scrutiny, that public scrutiny continues. Not everybody accepts a not guilty verdict, and so it can be very difficult to function in society afterwards.
But that
So she just made a correlation between, she asked him about a correlation between a fall from grace and an attempted suicide. He gave a long, rambling answer, but at the beginning of the answer, he said, yes, there is a correlation between a fall from grace and an attempted suicide. So she's pointed out to the jury that perhaps Robert Tellis's fall from grace is correlated to his suicide attempt. And if essentially, if he's willing to kill himself due to this fall from grace, is he perhaps willing to kill someone else due to this fall from grace? Because remember, the defense was saying there's no correlation here between his fall from grace, his loss of his position as a public administrator, all of these articles, and this particular crime. There's no correlation. She's getting their own expert to tell the jury there is a correlation or potentially a correlation. So that's a good job on her part.
public scrutiny would still exist and the embarrassment would still exist if you were guilty too, right?
Right.
And if, say, you were the subject of really negative articles that were published countywide, that would be a stressor that someone might experience as well, right?
Correct.
Being accused of inappropriate behavior in the workplace would be a stressor for somebody, right?
I would think so.
Being accused of being a bad manager would be stressful for somebody, right?
Almost certainly.
Okay. And sort of being accused of being kind of incompetent at your job would be a stressor if that was something that was like published to, say, the county.
Yes.
Okay. And those types of things cause stress on individuals that may or may not manifest as suicide, but they're troubling to individuals to experience. Is that fair?
Sure. Some more than others. It's all about personality and experience, but yes, I would think generally that's true.
And when you say some more than others, if they're someone who puts a lot of importance on their role in a particular office or status, it would be more upsetting for that type of person to have maybe negative articles written about them?
I would think so, yes.
Okay. Could I have the court's indulgence? Thank you.
Yes, just some follow-up. Based upon your testimony and your opinion, there's not really this correlation concerning more evidence against someone for a serious crime then results in a higher likelihood of suicide.
I'm sorry, could you rephrase the question?
Absolutely. So there was questions that you were asked concerning evidence in a particular case. Mm-hmm. And are you able to say there's any correlation between, let's say, the more evidence of a person having committed a crime, that being correlated to the higher likelihood of suicide?
I think it's probably more accurate to say that it comes down to the individual's perception of his situation. So, for instance, if someone believes that they're in big trouble, that the cops have them dead to rights, whether or not they're guilty, that probably produces more stress than somebody who thinks, yeah, I can get out of this, or I'm good, or you know, they don't have anything on me. So the objective status of that person's situation is probably less important than the subjective perception of the situation that they're in.
So again, that underscores, obviously you agree that human beings, we can be fairly complex and our behavior can be fairly complex.
That's pretty obvious, yeah.
It is, and oftentimes people think, well, if this person committed suicide, if he committed suicide, he must have committed the crime. You're here to dispel that common view.
Yes,
And there's actually scientific data that does so.
right.
Thank you. I have no further questions.
Any cross?
Nothing else, Your Honor. Thank you.
Okay, Mr. Hawes?
So what do you all think? Was that witness helpful to the defense? Did it hurt the defense, or did it have absolutely no impact on the jury? Let me know what you think.
You can approach.
So remember at the beginning, he said that they were moving at such a fast pace with respect to getting through the prosecution's witnesses that he had prepared his witness.
Has been marked as court's exhibit number 15. Has anyone in your experience ever attempted suicide in an attempt to gain sympathy from being accused?
I think that's almost certainly true, yes. Especially when the suicide attempt is not successful. Sometimes people do what we call suicidal gestures, which just refers to the fact that it kind of looks like a suicide attempt, but it wasn't fatal. And in many cases, people do that just to garner sympathy or to deflect attention from some other issue that they're concerned about.
So that was an excellent question from the jury. Do people sometimes attempt a suicide just to get favorable feedback, favorable feelings from others, to get sympathy for them from others? And his answer is yes. So I think that particular question is more, the answer to that particular question is more favorable to the prosecution than it is to the defense.
Any follow-up, Mr. Draskowitz?
I do, thank you. And in reference to this, and we're not saying that's necessarily the case in this case, are we?
No, I'm not at all.
And this perhaps deflection, this perhaps attempting to get sympathy doesn't necessarily equate to knowledge of guilt or guilt.
No, it definitely does not.
Thank you. I have no further questions.
Ms. Weber, anything else?
No, Your Honor, thank you.
Okay. Dr. Chambers, thank you very much for your testimony here today. You can step down.
Thank you, Your Honor.
You are
So Ms. Carroll thinks that
Thank you very much for being here.
all of that was more helpful to the prosecution. And I tend to agree, as does Natalie. Jeff says, I like how the prosecution let the jury know that he only interviewed Mr. Tellis. So that's also a good point. He didn't interview anybody else but Mr. Tellis. We don't know what he was asking Mr. Tellis. He didn't give Mr. Tellis any tests to kind of see if the information Mr. Tellis was providing was, misremembered in any way. And remember, the prosecution went back to the fact that he does provide expert testimony on how a witness may misremember things.
Before we had them set for later in the week, we'd anticipate our next witness being available after the lunch break, Your Honor.
Oh, okay, this afternoon?
Correct.
Okay. So at this time, we are going to break for lunch. During this recess, your much time to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. Read, watch, or listen to any news or media accounts or commentary about the case. Do research, consult dictionaries, internet, or reference materials. Do any investigation, test a theory, recreate.
All right, so it looks like they are adjourning for lunch. Just before we go, a couple things. It looks like they will be back at 4:30. So we will be back at 4:30. But before we go, let me share something with you all. This is one of those. Natalie said somewhere in the chat that she had seen some interviews conducted of Mr. Tellis, some of the things that he has said. So I want to share one of those with you before we go, because this is a video of him claiming that the real estate firm framed him for this particular murder. So if he does take the stand, that's kind of what we can expect to hear out of him, I guess, and kind of what this defense team has been preparing us for all along, that, between the police department and this Compass Realty Group, there's some sort of a conspiracy to frame him for this crime. This video is a little long, but I don't think we're going to need to play all of it. But let's just see some of what he has to say. This will also give us an idea of what we can expect from a tellus as a defendant as witness.
Morning, Your Honor, or afternoon. I'm in the habit of saying good morning too. Mr. Tellis, this is off of your motion to disqualify Judge Levitt. I have read the...
So this is, remember he's in jail and he's representing himself from jail. So he's here appearing in court, but he's in jail at the time. So this is this is motion practice. We're just not looking at the inside of a courtroom.
I have read your pleadings and Judge Levitt's response, but I'm happy to hear anything else you want to tell me.
Great, Your Honor, thank you. And so what I'd like to do today is I'd like to go ahead and discuss the truth of what has happened in this case. And I hope that Your Honor allows me to finish everything that I've got to say. Because as Your Honor knows, one of the core principles of our justice system is the pursuit of the truth. Now,
I'm happy to, I want to hear the truth, but I see you have a big stack of papers in your hand. We don't have time for all that today.
Don't worry. I am only going to speak to things that are absolutely relevant.
Okay, go ahead.
Great, thank you, Your Honor. So first I'll discuss Judge Levitt's deep-seated favoritism, and I'll finish by discussing why she's engaging in this misconduct. Now, I understand that Your Honor might be inclined to grant or, to give her the benefit of the doubt. However, Your Honor, the misconduct that's occurred here is well outside the bounds of any reasonable doubt. Judge Levitt, her favoritism is so deep-seated, she refuses to refrain from violating constitutional rights, and in turn, she's wasting taxpayer funds, and she refuses to acknowledge that as well. When, Judge Levitt engages in intentional misconduct, often the resources of the appellate courts, additional resources of the state, and additional resources of the public defender are wasted. And that's not to mention when often those who are wrongfully convicted have to bring civil suits. Now, all of this comes out of the taxpayers' pockets, and given that Judge Levitt has refused to stop violating constitutional rights, it seems she just doesn't care. And so, I think what is important here is to point out that this has got to stop. But let me continue though. I want to talk about Waller v. Georgia. In Waller v. Georgia, the United States Supreme Court said that evidence...
So in order to he's trying to get the judge kicked off of this case. In order to get a judge kicked off the case, you can't point to their rulings in the case and say this ruling demonstrates that she is biased in favor of the other side. You have to point to something that she did that is improper. She can't be using her judicial discretion and you not like the result that she comes to in order to get her kicked off the case. You can't do that. This is an attorney in the state that he practices in or that he used to practice in. And he's bringing this motion to disqualify the judge based on the judge's orders that he disagrees with. If you're going to try to get a judge removed from a case, at least have your ducks in a row. Even if they don't get off the case, if they can see why you're having them a justification behind your motion, they likely won't hold it against you. But if you're just trying to get them kicked off because you want a different judge who might side with you on some of these motions, well, the judge is going to be upset with you after that. The judge probably isn't going to like you and look favorably at your future motions. So this is just a bad idea from jump.
Suppression hearings are important means of both vindicating constitutional rights.
Let's try to fast forward to what actually
fulfilling the public's interest in
alleging
exposing police about Nevada law? No, but Judge Levitt did. And it is clear from Judge Levitt's later actions that she knew the claim was false. After Judge Levitt, the DA, and Metro stonewalled me on the evidence for several months, I filed a petition to have the Nevada Supreme Court intervene. The week after Judge Levitt received my petition, she immediately held another hearing on my motion. Now, if Judge Levitt really believed that she was lawfully withholding the evidence from me, why would she rush to hold another hearing on my motion? The answer is she knew it was unlawful. Now, and yet you will see that Judge Levitt continued to collude with the DA and Metro to keep me from receiving evidence critical to proving my innocence and the police misconduct. When I was being taken to court that day, no one could tell me what the hearing was about. I didn't find out that it was about my motion until the hearing had already started. And only the Metro was only the DA was in attendance, not Metro. During the hearing, Judge Levitt announced that the DA would be producing the evidence I was seeking and not Metro. And this was despite the fact that I had requested in my motion production by Metro with sworn certificates as to the completeness of the production. Now, when I reminded Judge Levitt of this, Ms. Weckerly jumped in and declared that I had not served Metro, and that's why they were not there. Now, an impartial judge would have recalled that Metro filed a response and attended 2 hearings on my motion, but not Judge Levitt. She immediately agreed that I had not served Metro. It was shocking to hear a judge absolutely disregard easily verifiable facts that are on the record. Now, prior to that hearing, there was no claim that Metro hadn't been served. Again, they had filed a response and they attended 2 hearings. Clearly, Judge Levitt and Ms. Weckerly had an ex-parte communication to come up with this ridiculous claim so that Judge Levitt could order that the DA produce the evidence instead of Metro. Now, would an impartial judge do that? No, of course not. What difference does it make how I received the evidence? The difference is that by ordering the DA to produce it without sworn certificates, then the DA can lie about the evidence, and they did. Had Judge Levitt actually granted me the relief I sought in my motion, I would not now, even 9 months after filing my motion, still be fighting for evidence of my innocence. One of my requests was for the surveillance logs and videos of the surveillance that was conducted on me, including surveillance during the bribery investigation. Ms. Weckerly told me that I was only surveilled 3 total times and that there was only 1 video. However, it is clear that Ms. Weckerly lied based on information I found in items that were produced to me. In one of the surveillance logs that was produced to me, I found that the surveillance log referred to videos, plural. And that same surveillance log referred to surveillance that was conducted just before
You can see how he's trying to use her rulings against her. He's basically saying, look, you ruled against me with respect to me getting this evidence. And so when the evidence finally came and you agreed that I should have it, well, I only got a little bit. I didn't get all of it. Well, this isn't the judge's fault. That it's not the judge's fault that the prosecution and or the police department, who we've already seen destroyed some evidence, and that we've already seen were ordered to hand over evidence to you, that it's somehow the judge's fault that this evidence was destroyed and you never received it. So why are we trying to get the judge kicked off? But let's try to get to where he starts talking about his theory of the case. That's going to be a little later in this video.
Filed an inventory report that showed a date of death condition of the home that had photos of the home with no flooring and no kitchen. When I say no kitchen, I mean no cabinets, no counters, no sink.
So he's
bare
talking
walls
about
and kitchen. And this is one of their MOs for reducing values of the homes. And
Compass Realty at this point.
You'll see the point of what I have to say here very shortly.
Reducing values of homes.
The person who was in charge of this, I believe, was a man by the name of Adam Fenn, an agent for Compass Realty. And that information will be relevant in just a moment. In early 2022, I approached DA Wilson about opening a criminal investigation into Compass Realty. He referred me to Detective Jappy in the Public Corruption Unit at Metro. I met with Jappy, gave him my materials, and his team went to work. Not long after that, Jaffe told me his team discovered that Compass Realty never reported personal property such as vehicle, jewelry, firearms, or other items of value, just by having opened over 200 cases. Now, Detective Jaffe told me his team would be setting up sting operations, documenting the items of value that were in the homes before Compass Realty had a chance to clean them out. And of course, obviously taking appropriate action once they built the case. The day or so after I talked to Jaffe, I spoke to Mr. Wolfson and told him the good news. Mr. Wolfson said he already knew. He said that he and Jaffe are good friends, and that he keeps on top of all of Jaffe's cases because those are the big publicity cases. Now, after that, I didn't hear anything more, and recently I found out why I believed. I discovered that Adam Fenn of Compass Realty donated to Wolfson at the end of March 2022, not long after my conversations with Wolfson and Jaffe. Wolfson's first quarter 2022 contributions and expenses report that shows Adam Fenn's donation is available for public download at the Nevada Secretary of State's website. The donation is on page 4 of that report. Also available for download is my successor Rita Reed's second order report that shows that Compass Realty donated to her, and Adam Fenn also donated to her 2 weeks before Mr. Gervin's first article. So the investigation into Compass Realty went.
So if you all have ever wondered how judges finance their campaigns, let me give you some insight. Every election year, attorneys get a whole bunch of invitations to fundraisers for judges. And let's say we are expected to donate to judicial campaigns because potential judges get the majority of their funding from attorneys. Other people generally don't care about judicial elections. They don't donate to the campaigns. They don't participate. Oftentimes, if you'll think back, you probably don't even know who's running for judge in your area until you arrive at the polls. You can't look at a judge's fundraise, the donations made to a judicial campaign, and say, these attorneys donated to their campaign, to this judge's campaign, and now this judge is ruling in their favor in this case, because one has nothing to do with the other. Often, attorneys donate to everybody's campaign because we go to all of the fundraisers so that we can shake hands not only with this person who we may see in court, who we may be before in court, but also all the other attorneys in the room. What he's saying is that Compass Realty gave a donation to somebody and also gave a donation to Rita Reed, and therefore that is evidence that there's some nefarious dealings going on. Donations to a political campaign can't be evidence of nefarious dealings. Every court has decided as much. And one of the reasons they decided it is because if they were evidence of nefarious dealings, every judge on every bench that was elected to office would have been engaged somehow in nefarious dealings just by collecting donations for their campaign. So this isn't evidence. He can't come into court and start talking about who donated to whose campaign because it doesn't matter. Let's go on.
Nowhere. And later when I continued my work against Compass Realty, Detective Jaffe opened a sham investigation into me, complete with surveillance. And this was just a little less than a month before someone murdered Mr. German. You can see why maybe Mr. Wilson wants to be convicted at all costs. Why he wouldn't mind it, or why he made Weckerly and Hamner lie and break the law to convict me. And I imagine that he didn't want me to discover and expose that Adam Fenn, the man that we were all trying to work together to build a case against, was giving him a donation. Interestingly, another attorney told me that Wilson had been known to take donations in exchange for leniency. And I checked a handful of names on Wilson's second quarter report and found that donors Sol Sayek and Leonard Ambrosino had both been convicted by Mr. Wilson in the past. It's kind of strange that these gentlemen would donate to the man that convicted them year after year. And the attorney that told me about this leniency in exchange for donations told me that Paris Hilton was one of the most famous examples of this. Now, I didn't get to check that, but if the records from back then are available, then I'm sure that it can be easily checked out.
Paris Hilton
So-
he's talking about now.
This is Steve Wolfson's reason for withholding evidence, for trying to break every rule in the book, and I believe that Judge Levitt knows it. I believe that Judge Levitt wants to protect him, and I think they didn't want me to find this information out. So, I mean, what else really explains her deep-seated favoritism and these numerous overt acts of misconduct, Your Honor? There's nothing, it's extreme what she's done. It's inexcusable. And Your Honor, I believe that if you do not disqualify Judge Levitt, respectfully, I think that it's going to send a message that, you know, money can buy anything, even the wrongful conviction of an innocent man who's just trying to stop crime. So in order to protect my constitutional rights, to prove my innocence, Your Honor, I'd like to ask you to please disqualify Judge Levitt. And as far as those reports, I've got copies here if you'd like to see.
So essentially, what you have here is a defendant trying to get a judge disqualified because he doesn't like the judge's rulings, and then piecing together a bunch of campaign finance contributions in order to justify the motive that this judge that he's before might have for disagreeing with him on the motions that he's putting before the court. He's essentially saying this judge is also conspiring against me because these realtors are giving campaign donations to, I believe it's the county sheriff who he's trying to get the evidence from, or the chief of police, one or the other. And she's trying to cover up for him. So the defense is apparently not only is it Compass Realty and these investigators who are framing me, but it's also the judge who's ruling against me because she's trying to cover up for the police department who won't give me the evidence that I need. So I really want this guy to take the stand, but this is the reason that he can't take the stand. He cannot appear on his own behalf because as he's weaving together this intricate conspiracy theory, the jury's going to look at him like, this is the best you can come up with? They found your DNA under the decedent's fingernails, and you're here talking about a conspiracy involving a real estate company, the entire Las Vegas Metropolitan Police Department, and the judge? Everybody wants to see you go down here? For Robert Tullis's sake, I really hope that his attorney is able to convince him not to take the stand. Miss Carroll, I don't know if he's still planning on taking the stand, but in another jailhouse interview that was conducted, he expressed his sincere desire to take the stand and tell his story. At the beginning of this case, just before day one, his attorney, talking to reporters, said, my client desires to take the stand. The attorney was very clear not to say that he wanted his client to take the stand or that it was part of his strategy for his client to take the stand. But as I said at the very beginning, if his client decides to take the stand, there is absolutely nothing his defense attorney can do about it. His defense attorney cannot say, no, you cannot take the stand in your own defense. We don't have that power. We're here to advise our client, help our client, give our client the counsel that they need from a legal standpoint and a strategic standpoint. But ultimately, the client gets to make the decisions. If Robert Tellis wants to take the stand, he's going to take the stand. And that's just the way it's going to be. I'm here for it. I hope you're here for it too. I want to see it. But for his sake, I don't want to see it. But let's put a pin in all that. We got to come back after lunch, see who the defense has in store for us. As I said, I don't know who they're going to be able to piecemeal together to try to make a defense. As we could all see, their first witness was not necessarily helpful to their case. Ms. Carroll nailed it. That was probably more helpful to the prosecution. So we'll see what they have next and see if they're ever able to deal with any of this evidence. I hope you all come back in the afternoon session for part 2 of day 5 of the Robert Tellis trial. For now, my name's Nathan Saunders, and this is The Legal Good. Thanks for coming.